So what is an administrative license suspension? Georgia says that if you are arrested for DUI and you register above the legal limit, whether it's a .02 for a person under 21, a .04 for a commercial driver's license driver, or a .08 for ordinary Class C license holders, Georgia can try to suspend your license even before you get to court on the actual DUI case. Georgia also says that if you refuse to take the state chemical test, your license can be suspended administratively, and that's the one that I want to talk about today. Because many people ask, if I'm stopped and arrested for DUI, do I take the state breath test, state blood test, or not? I'm going to talk about whether you can, or how to decide whether to take the test in another video, but for our purposes today, let's talk about what happens if you refuse to take what is commonly called the state chemical test. The procedure is you have to be placed under arrest, read the implied consent warning, and when the officer asks you if you will take a state, say, breath test, you say either no, I will not, or you don't answer at all, which is considered a non-verbal refusal. Now, we're not talking about the breath test on the side of the road. We're talking about after the arrest, where the officer is going to ask you to more than likely go down to the police station and take a breath test, and you say, no, I will not take a breath test, or you don't answer at all. Now, your license is not automatically suspended for 1 year. What happens is there is a process that the officer has to start to try to suspend your license for 1 year, and that's called the administrative license process. The way that works is the officer will take your driver's license, he will give you a form or a copy of a form called a 1205 form. That form acts as a 30-day permit to drive. The police officer sends the original to Driver Services. You have 10 business days from the date of the arrest to request a hearing on the issue of whether your license will be administratively suspended. If you do not do that, then your license will automatically be suspended on the 31st day after the arrest. It will be suspended on a refusal for at least a year, or if you can get into court and win the DUI, then you can get your license back. So the first thing is the officer fills out the 1205 form and gives you a copy. The next thing is you have 10 business days to send in a letter requesting a hearing. You have to send in a $150 filing fee for that hearing. That automatically extends your driving privileges. Now, usually within 30 to 45 days, you will get a hearing notice in front of an administrative law judge. The issue is whether your license will be suspended. It has nothing to do with whether you're guilty or not of the DUI. If a hearing is actually held, these are the only issues at an administrative license suspension. Did the officer have reasonable grounds to believe you might be DUI? Did the officer read you the implied consent warning properly? And did you, in this case, refuse to take the state-administered chemical test? So therefore, if you are arrested and you decide to refuse or not take any state chemical test, it is important, it is imperative that you get with a DUI lawyer quickly so that that DUI lawyer can file the proper paperwork to keep your license from being suspended, and at least set up a hearing situation where perhaps you can win the hearing, or you can work out an agreement with the police officer to not suspend your license for a year. So that's the administrative license suspension process.